In the name of Almighty Allah, welcome to this session of legal terminology. And the first term from corporate law and governance, we have amendment. Mr. Roma, would you like to share with us the definition?
Sure. Amendment. A minor change or addition designed to improve a text, piece of legislation, etc.
Thank you. Uh, so it is amendment. So the changes made in law in order to improve in terms of text or in terms of insertion of any next provisions, any further provisions, amendments are introduced in the law. And sometimes there is a widespread amendments, or sometimes amendments are just for a comma, semicolon, or a colon in any provision of law in order to make it commensurate with the changing needs of time, or in order to accommodate some of the judgments of the apex courts in terms of amending the law. So amendment is the term being used. Welcome to the Mehdi Raza. Please turn on your camera and join us with this legal terminology session. And I'd like you to read the next legal term, that is repeal. Yes, Mr. Mehdi, please.
Uh, can you hear me?
Yes, of course, please.
Okay, so the word is repeal. That means to revoke or annul a law or act of parliament.
That's right. So repeal, for instance, if we talk about Companies Act 2017, we are well versed with this fact that Companies Act 2017 has repealed Companies Ordinance 1984. So basically, this legal term is used for annulment or revocation of the previous law. And that repeal is the prerogative of the parliament, if it is the federal law, and the provincial assembly, if we talk about the provincial law. Next term is notwithstanding. Mr. Rama, please share with us.
Notwithstanding. Without prevention or obstruction from or by or in spite of.
Very right. So without any prevention or obstruction, I mean, nothing will be a hurdle in the way of application of law, which will be considered as having overriding effect. So notwithstanding the provisions in any previous law or in any other enactment, the provisions or the statutory provisions given in Companies Act 2017 will hold the field in spite of the fact that some contrary provisions are already given in any other law. So that is notwithstanding. Next is void, that is not valid or legally binding. As we discussed in one of the previous session, that something which is not of any legal effect or binding is called void. And when we say legally binding, it means that it cannot be enforced under the law, or no decree can be sought or a writ can be issued by the court of law if there is a law which is considered as void or which is being held as void by the apex court. Now we have term number 5. Mr. Mehdi Raza, please share with us.
Statutory. Written law established by enactments expressing the will of the legislature.
Right. So the acts of parliament or the provincial assemblies, those are called statutory laws, and these are the will of the parliament. This is the desire of the parliament. That is an expression we use for all legislation passed by the parliament, if it is the federal legislation, and if it is passed by the provincial assembly, then of course that is considered as the desire of the parliament. And since parliament represent the countrymen, so it will be considered as what is being desired or expected by the public at large. Next is override and repugnant. Mr. Rama, please share with us.
Override. Use one's authority to reject or cancel a decision, view, etc.
Right. So override, it is the authority, and that authority is, in fact, is the mandate of the court of law, actually, that the court can declare any provision as having overriding effect, or if it is the parliament, that can also be the will of the parliament, that parliament can pass a law which can have overriding effect over the other enactments if there is something contradictory or something contrary given. Repugnant. Yes, Ms. Aroma, please.
Repugnant. In conflict or incompatible with.
That is right. So if there is something contrary, as I said earlier, in any other law, we can say that is repugnant to the provisions of Companies Act 2017. And as 2017 enactment has the overriding effect, so if there is something which is contrary or repugnant, that cannot hold the field, or that cannot be given reverence by either the court of law or by the executives while applying. When I use the word executive, that is the government or the regulator. In this case, we have Securities and Exchange. Yes, Mr. Mahdi, next few terms. Yes, please.
Sue. Institute legal proceedings against a person or institution, typically for redress.
That's right. So if someone has any grievance for a redressal of that grievance, a suit can be instituted, or a writ can be sought, a petition can be filed, a complaint can be lodged, and that can be against an individual person, or that can also be lodged, filed, or in terms of writ, or in terms of suit, or in terms of a claim against an institution also. And when I say institution, I mean, if you are a student of a medical and dental college and you have any grievance against Pakistan Medical Commission, or you're admitting university, or that is University of Health Sciences, if you're in Punjab, then of course you can file a writ petition against that authority or institution in order to seek some redressal of your grievance. So that is to sue or to file a complaint or to lodge a complaint. Next word is cognizant. Yes, Ms. Aroma, please.
Cognizant. Having knowledge or awareness.
Very right. So to be cognizant of something, that you have the knowledge of that, or it is in your knowledge, if it is in your purview. Here we go. Yes, the next legal term is surcharge, and that means an overcharge or additional cost which can be imposed by the regulator in terms of any default by the consumer, as it happens in case of LESCO or the distribution companies functioning in Pakistan under PEPCO, or it happens in terms of Sui Northern Gas and Sui Southern Gas, that if there is a consumer default, there is a surcharge which can be imposed. Next term, yes, Mr. Mahdi, please.
Penalty. A punishment imposed for breaking a law, rule, or contract.
Well, it is pretty easy to understand that penalties can be imposed. And this is actually the very gist of law, that any legal provisions which can be considered as legal provision are the one actually that in case of avoidance or violation or infringement, then the penal consequences can accrue, or one can be held liable for a penalty if there is any avoidance of law or if there is any infringement of law. So penalties can be imposed, that is a synonym for punishment, very often used in our legal terminologies. Mr. Rama, next term, please.
Prospectus, a formal legal document designed to provide information and full details about an investment offering for sale to the public.
Right. Here in corporate law, when a company is, if it goes to public actually and offers public to subscribe its share, then the very document which is issued under the law is called prospectus, or we use in lieu of the prospectus, a statement can be issued. So prospectus is that very legal document which talks about the company if it is going to launch its initial public offering. So the very prospectus, the document actually, it provides all the information and the details regarding the kind of investment, the sort of projects planned to be undertaken by the very company. And so through this document or through the prospectus, public at large is invited to subscribe the shares of that company and make an investment in that company's shares. Next, please, Mr. Mehdi, please.
Right, sir. Plea, a formal statement by or on behalf of a defendant or prisoner stating guilt or innocence in response to a charge, offering an allegation of fact, or claiming that a point of law should apply.
That's right. So this is a stance or view taken by someone who is before the court of law. The very word or the legal terminology we used is the plea. Next, please.
Petition. A petition is a formal request seeking a specific court order made by a person, group, or organization to the court, typically at the start of a lawsuit.
That's right. So in this legal course of in the legal course, actually, the applications moved either before a court of magistrate or the civil judge or the district judge or the high court. So those applications are used. The term we use is, or term used is petition. Next, please, number 15.
Prejudice, harm or injury that results or may result from some action or judgment. Prejudice resulting from delay in the institution of the proceedings.
So that is the harm actually which can be caused to a person if is passed against him. So the person who to whom or against whom the judgment is passed is called judgment debtor, and the decree holder will actually, once he goes for the execution of that decree, of course, this is how the harm, injury, or prejudice can be caused to the judgment debtor, and judgment debtor has a right to challenge or impugn the very decree or the judgment against which he has any prejudice. Next is mandate, a commission by which a party is entrusted to perform a service, especially without payment and with indemnity against any loss by that property. So mandate by that party. So mandate is the very permission or the instruction under which the job is performed or assignment or service is rendered. Jurisdiction is the next word, the extent of the power to make legal decisions and judgments. In case of Companies Act 2007, any dispute, if it has arisen between the shareholders or between a shareholder and a company or between different companies, or if there is any claim of a company against the regulator, then the jurisdiction lies with the Honorable High Court under Section 5 of Companies Act 2017. So the claim will be within jurisdiction of the Industrial Tribunal. This is just an example quoted here. So in case of Companies Act 2017, the claim will be within the jurisdiction of company's court or the company's bench, actually. That is the Honorable High Court's bench. Next is invasion. Yes, Mr. Mahdi. Evasion.
evasion, the action of evading something. The synonyms are dodging and avoiding.
Please.
Affidavit, a written statement confirmed by oath or affirmation for use as evidence in court.
Please.
Injunction, a judicial order restraining a person from beginning or continuing an action threatening or invading the legal rights of another, or compelling a person to carry out a certain act, for example, to make restitution to an injured party.
Injunction can be issued by the court to restrain someone not to do certain act or to direct someone to perform certain deed. These are issued by Part A. Yes, please.
Ex parte. It's an adjective done with respect to or in interests of one's side only or of an interested outside party. In terms of an adverb, it's with respect to or in interests of one side only or of an interested outside party.
Part A actually is used in the proceedings where defendant fails to appear before the court, or if on even after the newspaper proclamation, a defendant is unable to appear before the court, then ex parte proceedings. Please.
Inter alia, among other things.
Aroma. Next definition, please.
Bailiff, an officer who executes writs and processes and carries out restraints and arrests.
Please.
Adjournment, an act or period of suspension or being suspended.
That is right. So adjournments can be granted in the proceedings, and that is a period of suspension or adjournment in terms of a case. Bailiff is an officer who is appointed to execute certain orders of the court, which includes the arrest of the accused, etc. So with these words, thank you very much.